Sri Lanka. Recovery of stolen public assets. Lessons from other countries. Video series, video number 20. This video provides information to the general public on how Sri Lanka could recover stolen public assets, learning from the experience of other countries. I am Dr. Shanti Mendes. The video will present 3 case studies from Nigeria, Peru, and the Philippines, and lessons learned from the experience of these case studies. Case study 1, Nigeria. General Sani Abacha, who governed Nigeria from 1993 to 1998, is estimated to have looted $3 to $5 billion over the 5 years of his rule. 4 methods were used for plundering public assets: outright theft from the public treasury through the central bank, inflation of the value of public contracts, extortion of bribes from contractors, and fraudulent transactions. The corruptly acquired proceeds were laundered through a complex web of banks and companies in Nigeria, the UK, Switzerland, Luxembourg, Liechtenstein, and the Bahamas. In 1998, a special police investigation was launched to investigate Abacha's theft. In 1999, General Abubakar issued Decree No. 53, which facilitated the domestic recovery of $800 million in cash and assets from the Abacha family and associates. President Obasanjo, who assumed office in 1999, redoubled the effort to find more of the stolen assets and engaged a Swiss legal firm, Monfrini and Partners, to assist with tracing and recovering of monies held abroad. In 1999, Swiss authorities accepted the request for mutual legal assistance, leading to the issuance of a general freezing order. Swiss law required that Nigeria presents a final forfeiture judgment reached in the Nigerian courts. Monfrini and Partners, the Swiss firm, argued successfully that since there was adequate proof of the criminal origin of the Abacha funds, Swiss authorities could waive the final forfeiture requirement. It took Nigeria 5 years to obtain a repatriation decision from the Swiss authorities due to numerous appeals brought by the Abacha family. The World Bank was selected as a third party for the monitoring of recovered assets. Repatriation took place in 2005 and 2006 for a total of $505.5 million. Second case study is from Peru. When President Alberto Fujimori was in office in 1990 and continued till 2000, the intelligence police chief Vladimiro Montesinos stole more than $2 billion from the state through the extortion of bribes in awarding national defense procurement contracts. Montesinos used shell companies based in tax haven jurisdictions that were managed by trustees. After Fujimori's resignation, the new government, led by President Valentin Paniagua, redesigned the legal and institutional framework. These legislative and judicial reforms of President Valentin proved fundamental to the advancement of investigations and the repatriation of at least a part of the stolen assets. In November 2000, Swiss authorities froze $48 million linked to Montesinos. In March 2001, the Cayman Islands froze nearly $33 million, which was repatriated to Peru in August 2001. In August 2002, after almost 2 years of investigation and litigation, Swiss authorities returned $77.5 million to the Peruvian government. In January 2004, after the signature of a bilateral agreement, the United States repatriated to Peru $20 million in funds that it forfeited from Montesinos. The third case study is from the Philippines. Ferdinand Marcos was toppled by a people's revolution. He is estimated to have siphoned off between $5 to $10 billion from the Philippines. He accumulated wealth through 6 channels: outright takeover of large private enterprises, creation of state-owned monopolies in vital sectors of the economy, awarding government loans to private individuals, direct raiding of the public treasury and government financial institutions, and kickbacks and commissions, and skimming of foreign aid. All these modalities have also been used by those who stole public assets in Sri Lanka. The proceeds of corruption were laundered through the use of shell corporations, which invested the funds in real estate inside the United States, or by depositing the funds in domestic and offshore banks under pseudonyms or accounts with code names. In February 1986, the Presidential Commission on Good Government was launched and made responsible for recovering assets, a very important step taken by the Philippines. Informal representations were made first to the United States government and the Swiss courts to freeze Marcos' assets abroad. In March 1986, Swiss authorities froze Marcos' assets in Switzerland. In April 1986, the Presidential Commission filed a request for mutual assistance with the Swiss Federal Police Department. In December 1990, the Swiss Federal Supreme Court authorized the transfer of Swiss banking documents on Marcos deposits to the Philippine government. It gave the Philippine government 1 year to file a case for the forfeiture of the deposits in the Philippine courts. In 1991, the Presidential Commission filed Civil Case 141 in the Sandigan-Bayan seeking to recover the Marcos assets. Sandigan-Bayan is the oldest specialized anti-corruption court in the world. In August 1995, the Presidential Commission in the Philippines filed with the District Attorney in Zurich, Switzerland, a petition for additional request for mutual assistance, which showed that the Marcos assets in Switzerland were a product of embezzlement, fraud, and the plunder of the public treasury. In August 1995, examining magistrate Peter Consande ordered all Marcos-related securities and accounts be transferred to an escrow account, a third-party account that is, with the Philippine National Bank. However, the Zurich Superior Court of Appeals denied this order. The Philippine government did not give up. In December 1997, the Swiss Federal Supreme Court upheld Consande's order and in April 1998, the Swiss deposits were transferred to an escrow account in the Philippine National Bank. In July 2003, the Philippine Supreme Court issued a forfeiture decision in respect of the Marcos Swiss deposits. On the 4th of February 2004, the Presidential Commission remitted to the Bureau of the Treasury the amount of $624 million pertaining to the deposits. What are the lessons from these country case studies? The process of recovering stolen assets is time-consuming and costly. It depends on the success of the recovery. It depends on a comprehensive strategy that defines goals and targets, identify all available laws and regulations, mobilize the needed expertise and resources, and make stakeholders accountable. So a comprehensive strategy is very important. Second, a clear and sound legal framework is essential, without which no success can be expected. Third, addressing operational barriers that delay asset recovery is critical. For example, difficulties in identifying focal points to make mutual legal assistance requests. Mutual legal assistance request is a formal request made by a country to another country for assistance in a criminal investigation or prosecution. So it's important for Sri Lanka to identify focal points to make mutual legal assistance requests and avoid delays in responding to these requests. And it's also extremely important maintaining contacts and coordinating the asset recovery actions, which are complex and time-consuming. Thank you for your attention.